it's invited me because I happen to be working as the master, the family law master for the Circuit Court for Allegheny County. I'm the only person who's ever served in that role. In the late 1990s, if you were to take a snapshot of the courts of Maryland, you would see that in Baltimore City and a few of the other metropolitan areas, they had masters, assistants to the judges who were appointed, not elected, who hear cases and make recommendations to the judges, but not final decisions. Western Maryland had one part-time master to deal with child support, and we still have one part-time master to deal with child support. But to deal with other kinds of family law, please come in.
I'm so sorry.
I'm just getting started.
I
It's
thought
okay.
it
It's
was
all right.
later.
I think, Christy, I gave you all the extra. I'm just sort of introducing myself by talking about what my role is at the court. So the master is a person who assists the judge, or judges. We have two judges, circuit court judges, and I hear certain kinds of cases, which I'm allowed to do according to the state laws and the state rules of procedure of the courts. 3 days a week, most of the time I deal with family law problems. They're still involving children for the most part, but people who can't figure out where the child should be when they're divorcing or separating. People who have uncontested divorces. People who've been to court years ago and now they want to have a retread, they want to redo how their custody and visitation arrangements are. So I deal with that about 3 days a week. 1 day a week I deal with delinquency cases, again with children, and then on Fridays, which we're going to find out about tomorrow if you make it to court, I deal with children in need of assistance, children who've been abused or neglected. And I've been doing that since 2000. I was the first person appointed to do that, and I've been doing it since. Before 2000, I was an attorney in private practice, sometimes in my own office, sometimes for the Legal Aid Bureau. Much of my work has been, I got out of law school in 1984, moved to Cumberland from the DC area after I got out of Catholic University, and I've spent my entire legal career working in Allegheny and Garrett County for the most part. Occasionally some other places, but mostly here. And I've lived here that whole time. I have 2 children. They're both away from the area now. One is in college, the other just graduated last year. So a little bit of information that I've gleaned through them about the local school system. And when as an attorney, I've dealt with children an awful lot. When I first joined the Legal Aid Bureau in 1985, straight out of law school, I represented children, sometimes parents, and that continued. So I've been in juvenile court virtually the whole time I've been an attorney. And I never would have guessed that I would have done that because I went to law school to deal with adult problems. I'd been a teacher before that and thought, oh gee, there must be a way to help out with these other kinds of societal problems. But I then found that it's all connected to the way kids are treated. So, I guess I would like you to at least tell me your names. I'll instantly forget them unless I hear it 2 or 3 times. It's just the way my memory works. But please tell me your name again.
My name's Andrea Vance.
Andrea. Okay, thank you.
Luann Walker.
Carol Heinberger. And
You have a name.
You know me.
you know her, Darlene Collins. D works. I meant to tell you that for nickname. D.
Good to know.
Yes, that was down the
Write that down. It's hard for kids to remember everything.
That's probably supposed to be very cute.
That's my golfer friends call me D.
Oh. Well, surely will show up eventually.
That's probably why she's like, yeah.
Well, let's look at this stuff that I pulled together. When you sit in juvenile court, you may, or when you read documents that deal with juvenile court, you some terms. And you may think that, oh, well, I sort of know what that word means. It's a common English word. Well, unfortunately, we use words with special definitions. They may be regular old words like abuse, but in juvenile court, they have the definitions come straight out of state law. And that's what I've copied out here. There are 3 pages or 4 pages of definitions, and they're out of the state law that deals with juvenile court cases. So let's look, if you flip through that, you go to the word party. We are having a party, I guess. That's not what this is talking about. CASAs are not parties to a case. Who is a party to a juvenile court case? A party is somebody who gets to sit at the table, who gets to speak, who gets called upon, who is a major player. That doesn't mean CASAs aren't important. Doesn't mean that social workers aren't important. The child is a party. In some jurisdictions, that's not the case. And in fact, in our state, we are lucky to have enough money to be able to pay for attorneys for every child. In many states, because they don't have enough money or spend it for children's attorneys, they will have someone called a guardian ad litem, which is essentially a CASA. My now deceased father-in-law was a guardian ad litem in Florida. And when I talked to him about his role, it was essentially what you were being trained to do. He was a person who went out and visited some children who were in foster care, came to court and gave his opinion to the judge on what he thought was missing, what could be done. He befriended the children, but I wouldn't say he was a friend. That wasn't his whole role. He looked at where they were living. He had opinions about the whole system, but that wasn't what he was there for. But CASAs aren't parties. Neither are foster parents. In fact, one time as an attorney, I represented a foster parent who had a child placed with him from out of state. And he got into a squabble with the out-of-state social worker, and she said, "I'm coming tomorrow and I'm taking that kid away from you." And he had hoped to adopt this child. And he was just beside himself. And we went to court and lost because he didn't have rights. He wasn't a party. He didn't have custody of that child. So who are parties? Well, it's listed there. The child's parent, guardian, or custodian. The person who had the child at the time that the child first came into court is pretty significant. And usually that's a child's parents. The petitioner, that's always in our courts the Department of Social Services. So if I were going to take notes, I'd write DSS. And the last one never happens in our court. It's a person who's charged with a crime. We don't deal with crimes in our juvenile court. We could, because it's in the law that we could. But it's the crime of causing a child to be a child in need of assistance, contributing to the condition of a child. And people do get charged with that, but it's handled in our regular criminal courts. So you won't see that. So the players are the children, their parents, and the Department of Social Services. However, sometimes we'll get someone called an intervener, a grandparent who really wants to be involved in the case, wants to sit at the table, wants to be able to call witnesses, and they will file a motion and ask to be recognized as an intervener because they might possibly be a placement, and not just a placement, they want to be a participant. That doesn't happen very often, but it can happen, and then once that person is declared to be a party, they're a party. So why do kids come to juvenile court? Well, 2 reasons: abuse and neglect. And if you look back on the first page of definitions, you'll see the definition for abuse. And it's stuff that is not very lovely. Sexual abuse, whether or not a physical injury is sustained or not. Physical or mental injury of a child under circumstances that indicate that the child's health or welfare is harmed and is at substantial risk of being harmed by a parent or other individual who has custody of the child or a household member. So if an occasional visitor to the home abuses the child, that's not abuse under this definition. Why is this definition so narrow? It's not just any injury either. It's got to be an injury that shows that the child's health or welfare is harmed and there's a substantial risk of being further harmed, perhaps. We have a tension in our whole court system and our whole country that's based on the Constitution. It's a respect for parents' rights. And it's not spelled out in the Constitution. You can read the Constitution, you can read the first 10 amendments, you won't see it, but it's there. It's in the First Amendment. And it has to do with the protection of people's fundamental right to raise their own children. We don't want the state coming in and monkeying with that unless it's absolutely necessary. And when it's necessary, the court takes on the role of kind of a parental role. In Latin, in Old Latin, it's called parens pater. The idea that the court can exert some power over a child and try to control the child for the protection of the child and using the best interest of the child stand. Well, we have a few abuse cases, but quite frankly, most of the cases that come through juvenile court are neglect cases. So if you flip over a couple of pages, you'll see the definition that's used in state law for neglect. It's all the way from locking your kid in a closet or in a car, or deciding you need to party so badly that you leave your kid overnight. But it's not just leaving your child. It has to be that there's a potential of harm, substantial risk of harm, or that the child has suffered a mental injury. It's really hard to prove mental injury, but sometimes it happens. We've only had a handful of cases over the years where I believe the mental injury was the main thing. Particularly if a child has already been diagnosed with a mental illness and the parent is just not taking care of getting the child to treatment. Or if the parent is doing something that makes the condition worse, then that might be a mental injury. So, before a child really comes under the power of the juvenile court, either abuse or neglect has to be proven against both parents. And here's the definition that brings a child under the court's power. It's called a child in need of assistance. There it is under F. A child needs or requires court intervention because the child's been abused or neglected or has a developmental disability or a mental disorder, and the parents are unwilling or unable to provide proper care and attention to the child. And it's both parents. So what happens if parents are separated? Parent number one has the child. Parent number two isn't in very frequent contact with parent number one. Parent number two doesn't do anything wrong, and parent number one does something wrong, or somebody in her household, his household, does something wrong. Well, we have a way of dealing with that. It's a state law that says you still bring the petition into court, and if the proof is only against one person, the case gets dismissed with a final order that grants custody to the parent who didn't do anything wrong. And that does happen. I would say maybe once a year we'll have a case like that.
What if that parent does not want to be responsible for the child?
Well, then that parent is unwilling or unable to provide proper care and attention.
Okay.
And we have that more frequently.
Yeah, that's what
Then the child comes under the court's power.
Okay.
Then the parents have to decide in the future whether they want to take care of that child in the right way. Please come in.
Hi.
I'm
Hello,
sorry.
how are
Hi,
you?
just fine. How are you?
Fine. I didn't know it. I thought it was 6 o'clock.
You have another copy?
We do.
Yes, we do. This is Shirley. See what happens when I move?
We're still in the first section. I introduced myself, and I'm sorry you missed
We
that.
used to ride together.
But in quick version, I've been the family law master since the year 2000. Before that, I was an attorney. I represented a lot of children, a lot of parents, and I have 2 kids myself, and they're out of the area now, and we're talking about terms.
Okay.
And we just talked about child in need of assistance.
Oh, thank
You
you.
got one?
You have an extra one?
Oh, I'm sure.
Looks like it came from
I'm
the
about you.
Okay, I'll use Cosmo.
Okay. You know,
Sorry.
Kazar, yeah.
So, how does a child get to be found, declared to be a child in need of assistance? What's the court process? Well, there's some other terms in here that name the types of hearings that we have. And the hearings are, very quickly, for most children, if they're removed because of a danger to them, there's an immediate hearing, an emergency hearing, called a shelter care hearing. And then after that, there's a judging hearing where it's decided whether or not the child is in need of assistance, or at least whether the facts that the Department of Social Services has claimed are true are decided. That's called an adjudication hearing. And then there's a disposition hearing. And then there are review hearings. And then there's a permanency planning review hearing. So, I went through that very quickly. Let's look first for the definition of a shelter care. Look on the last page of definitions, the 4th page of definitions. Shelter care. Shelter care is the temporary placement of a child outside the home. And usually the way that works is the Department of Social Services gets a report. They go out and investigate. They determine that the child is at risk. They try to work with the parents if it's possible. If it's not a super duper emergency, they'll try to work with the parents to see if they can't solve the problem. Sometimes they'll put together what they call a safety plan. And they'll come and visit the parent who's got the children from time to time. Other times they look at the situation and they say, whoa, this is just too risky. We can't have a child here. They'll prepare a petition. They'll take the child, try to find an emergency placement for the child in a foster home, and or sometimes with a relative. And then they'll file a petition in court, and the next court day after the filing, we have a hearing. Very quick. Nobody is really prepared for that hearing. An attorney is appointed right away for the child. In our county, the Legal Aid Bureau has a contract to represent all children in child in need of assistance cases, these kinds of cases. So they are able to quickly assign someone and hopefully do a few hours of research, call the social worker, ask what's happening, maybe meet with the child, maybe not. The parents are told when to come to court, and the attorney for the department comes to court, and probably 75% of the time there's an agreement in shelter care. But that's really the most urgent hearing. If you can imagine yourself for a moment as a parent who's just had your child taken away from you, it's quite anxiety-producing for most people. And if you can imagine being a child who's only been in, let's say, the mother's care, or sometimes both parents' care, and then suddenly you're taken to a stranger's house. And if you're a child who's old enough to have awareness of that, that's really quite shocking. So it's a very difficult kind of situation, and the question really at that hearing is there an emergency that needs, where the child needs to be protected? And most of the time, if the department has found an emergency, that's what happens. But it's a hearing. I'm a neutral. I'm not on social services side, not the child's side, not the parent's side. I have the hat of the child to a certain extent. I'm looking out for what's in the child's best interest. That doesn't necessarily mean what the child wants, but it's what is in the child's best interest. And in this first hearing, it's, is there an emergency that would make it so that it's contrary, it's against the child's best interest to remain in a parent's care, either parent. So we have that hearing. Sometimes it's a trial, very quickly organized. Social worker might testify, one of the parents or both of the parents might testify. Rarely do we have other witnesses. Almost never do the children testify. And a decision is made, and that decision is very temporary. Only can last up to 30 days at the shelter care hearing. And then the next hearing is to see, and at that hearing, you won't see shelter care hearings generally, because constables are not going to be appointed that way. You might, under a circumstance where the kid's already been in foster care, went home, something went wrong, and then we had a new shelter care hearing. That's possible. But I wouldn't expect you to be in attendance in most of the time at shelter care hearings. That's why I'm spending a little time describing it. The next hearing, you also will not be present. It's called an adjudication. And that's a fancy word for can they prove it? The petition prepared by the Department of Social Services claims certain things, and it has to claim things that, if they're proven, would show that the child is a child in need of assistance, that both parents are unwilling or unable to provide proper care and attention, and the child's been abused or neglected. And generally, it will go on the petition itself, which you probably will get to see at some point. It goes on for a page and a half, 2 pages, 4 pages sometimes, of what's been going on from the social worker who prepares it, from that person's perspective. Sometimes they can prove all of that easily, sometimes not. The standard that we use for proving things at the shelter care hearing is looser than the one we use at adjudication. I don't know if you're familiar at all with the idea of hearsay. It's secondhand evidence. In other words, if a child talks to a social worker and says, the boyfriend whacked me, the social worker at the shelter care hearing can relay that and say, the child told me that the boyfriend hit her. But at the adjudication hearing, the level of proof has to be higher. It has to be firsthand evidence. It has to be evidence that is generally not that kind of thing through the social worker. There are special conditions under which it can, but for your purposes, I think, I'm not trying to make you into lawyers. We've got too many of those already. So it's a higher level of proof, and so it's often where if the parents are really in disagreement with this removal, they'll have gotten an attorney by then, and they're entitled to a free attorney through the public defender if they can't afford one, and the child will have an attorney, and we'll have a trial. And again, I'm the neutral person who makes the decision, has the Department of Social Services proven their case by, it's the lowest standard of evidence we use in court. It's not like criminal court where we assume beyond a reasonable doubt. It's a lower standard. It's a little bit more than half. You might say 51%. It's called a preponderance of the evidence. And then if they have proven what they've claimed, we go to a second part of the hearing, or sometimes, rarely, it's a separate hearing. It's called disposition. So if you look on the second page of definitions, you see where it describes disposition. And that's where the final decision is made, is the child in need of assistance. Before it was about the facts. Can they prove the facts? And here it's kind of, have they proven the full summary that both parents are unwilling and unable to provide proper care and attention and the abuse and neglect. And also, what should happen to the child? Where should the child be and under what conditions? So, most of our cases involve parents who are substance abusers. Statistics say 11% of parents are substance abusers of some kind. But in our court, people who are neglectful or abusive, mostly neglectful of their children, I don't know the exact percentage, but it feels like it's 95%. So, as Ka says, you're going to be dealing with children who come from homes where there's some kind of substance problem. Pretty likely. And that means the child you're dealing with is at risk. 2 counts, 2 reasons why that child's at risk. 1, the child's been traumatized by abuse or neglect. The child's probably been traumatized by removal from the home, so they've had lots of trauma. And on top of that, they may have a genetic predisposition to being a substance abuser, because they've been around, they come from the line of somebody who is a substance abuser. And there's also the trauma of being around a substance abuser. Yes, ma'am?
Does the child understand that they're in that kind of atmosphere, or they don't know that?
It depends on the child. Depends on the child.
the age of the
I
child.
have a child coming to court tomorrow who I believe is in juvenile court because she said, I don't like to be around mommy when she's using drugs with her boyfriend. Now, she was an older child, older elementary school maybe. So she's aware.
So she's aware.
Now, younger child, you know, and you get into the tension, of course, that as children, we don't have anything to compare. We know our parents, and we love our parents, and our parents are not perfect, but we think they are. Every child grows up like that, I think, or close to it, at least very young children. And so we often see a close bond between the child and the child's abuser, or neglector often. So that makes it very difficult, for example, for the child's attorney. What's the position going to be? And Cynthia Fenimore came and spoke to you about the Legal Aid Bureau's standard of representation. And from the outside, that often looks very odd, particularly for children who are in the early elementary school age years, because they can speak, they can say what they want. It's not always a well-reasoned out kind of thing. And does the attorney go with that? The attorney go with what the attorney thinks is best interest. And you're charged with doing best interest. You could have a 17-year-old kid say, well, what I really want to do is drop out and smoke dope. And probably you wouldn't tell the court that you thought that that's what should happen.
If so, they need to come back to training.
We need remedial training.
Yes. CASA 101.
So the disposition hearing is an important juncture, and it's going to be after that disposition hearing that you are appointed. Let me give you, there's a flow chart there that is really hard to read, but it's very important. And I got this at the CASA conference that I went to. Okay. It was prepared by someone from the Public Defender's Office, a very experienced attorney. I believe she prepared it while she was working for the Administrative Office of the Courts. So we have talked about the Senate petition about there being an investigation. That's the referral to protective services. Sometimes they do now what's called an alternative response, which means they're not going to take the case to court. But if it's headed toward court, then they'll file a Senate petition. That petition could be non-emergency. I would say every year we have 1 or 2 cases where they don't remove the child before coming to court. They are they've been working with the parent, but the parent's not really cooperative, and there's some problems. There's been abuse or neglect. They're still a little concerned, but they don't think it's so dire that the child has to be removed. That's not very frequent, though. There is not removal. But if there's a shelter care, we'll have an adjudication. If there's no shelter care, we'll still have an adjudication. So it's possible for them to file a petition, not request shelter care, and then just ask to have it tried as an adjudication. And then the disposition hearing, and under our current law, the adjudication and the disposition usually happen the same day. So it's really one hearing. If you were sitting there, you go, well, what happened? And one person might tell you adjudication, somebody else might tell you disposition, and the person with the right answer would say, oh, adjudication and disposition. Didn't you hear him say, are you ready to go ahead with disposition? You won't hear all that. It's going to, it's something that will happen before you get appointed. In our court, we are really lucky to be able to have hearings fairly frequently. I say lucky for this reason. Parents with substance abuse problems are, as part of the disposition order, told to do a bunch of things that should help to improve their position and make them prepared to give proper care to their child. If you're told to get an evaluation at the health department or somewhere else to see if they need substance abuse treatment, and then to go, and to submit to random urinalysis to see whether or not they're still using it.
Is that available to them free?
I believe so. But that is a big issue, about availability. I think it's worse in other counties than it is here. We are, to some degree, fortunate to have a fair number of publicly available treatment places. The health department only provides abstinent-based substance abuse treatment. There are other places that use substitution drugs called buprenorphine, Suboxone, or methadone. And I would recommend, I've just spent several days looking into how substance abuse treatment is talked about because I'm helping out with a training about that for judges. But I think, even though I've dealt with substance abusing parents now for years and years and years, I think my ability to learn about that is still increasing. And I would recommend you delve into that because our common attitude of, oh, if they just had, a little bit more willpower, they could do it. I'm not sure that's the right approach. I think if you're really in the midst of addiction, your brain is messed up. And it makes it very hard for you to think straight.
So do they go to the hospital for withdrawal?
Some people do, but that is not the most common treatment anymore. The kind of treatment, of inpatient treatment, is much rarer. It's not generally the hospital, but there is an inpatient unit at the Finance Center. There are other inpatient units other places. That's not often done.
Do they
It's
die
expensive.
during the withdrawal?
Withdrawal? Well, that's one of the reasons for these substitution drugs. Methadone and Suboxone take away some of the withdrawal issues from heroin.
But they're still a drug, so they're still drug related.
Well, that's why I ask you to get educated, because the World Health Organization, I'm no doctor, I'm a lawyer. I've never studied this stuff except as a person who is a voracious learner. And I've tried to educate myself about this all the time. And what I've read is the World Health Organization has a protocol that says it's better to be on methadone or Suboxone for long periods of time rather than going back to heroin. So if you can take on the attitude of, oh, this is an illness, would I tell somebody who has cancer that they have to tough it out if there was a drug that could help? I'm not talking about pain meds, treatment medicines, or diabetes. We don't blame people for having illnesses. And I'm not sure I completely believe this. This is what I'm giving back to you from the treatment professionals.
Do you have some resources to recommend to us?
I will get you some that you can look
Okay.
at. I've particularly been looking
Something
at some
online.
videos that are online that are done by a person who's the head of the National Institute of Drug Abuse.
Oh,
Okay, and you can find out lots of information that she's put out. She's been interviewed a gazillion times, and she's a really interesting person. She has a thick accent. She's from Mexico. In fact, you can even run across some lectures by her in Spanish if you want, but she speaks English. This is with an accent. And she's the head of the National Institute of Drug Abuse. And her research is based on doing studies of people's brains using scans and seeing how different drugs affect the brain and how they produce fairly long-lasting effects on certain parts of the brain. And she's really got an interesting approach of not trying to criminalize addicts. Maybe drugs, but not addicts. She's not in favor of decriminalization of drugs, I don't think. But she sees a failure in what we're doing, stigmatizing people, making them feel guilty, and not really giving them much treatment. So, but that's a long, difficult topic, and I only spend this much time on it because so many of the people who come into juvenile court have addictions problems.
But can't you go to the hospital and they put you in a coma and then you come out and you're healed?
You're not healed because your brain has been affected to a point where you crave a drug. There is no magic bullet, there is no total cure, and there is nothing about a permanent cure here. People relapse. They can go through months and months of treatment and they can still relapse occasionally. And that is really a concern for me because if the juvenile court quits its involvement and social services is no longer in the picture, and then the person relapses, what happens to the child? And who's going to know? Well, hopefully there's a support community and a person can have a period of, a short period of relapse, get more treatment, and be prepared to take care of the child again. That's not easy. So the flow chart shows you kind of where things go in the case. This tells you a little bit more about timing. So there's a shelter care hearing, and the decision made there is only good for up to 30 days. Then there's an adjudicatory hearing, and often the adjudication and the disposition are at the same time, but they could be 30 days apart. So up to 60 days from the time of the shelter care.
Is the adjudication the same as the Seneca?
It's where SINA would be found, is at the adjudication and disposition hearing. The final SINA finding is at the disposition hearing itself.
Oh.
Now, in the 1990s, under President Clinton, I think it was, 1997, there was a law passed called the Adoption and Safe Families Act that tried to put some emphasis on getting children out of foster care as soon as possible, either into adoption or back home, or with a relative, or some other permanent placement. Is that fun?
That's my
There is a cure for that.
I thought you had a pet in your
Which
purse.
reminds me,
I don't
thank you
know how
for
to
that.
do it.
Thank you for that teaching moment. When you come to court,
No cell phone.
turn off your cell phones.
I never learned how to do it.
That's funny.
Or they'll keep them in the off or in the
Oh,
front
yeah,
area.
they take them away from you.
Not always, but maybe, I don't know. I know they don't take them away from attorneys, but I said earlier that we're fortunate to be able to have hearings more frequently than just every 6 months. And the reason why I've felt that that was important is because with people who are very impulsive, who are just starting to recover, I'd like them to come in and face me and say, yes, I'm still using, or no, I'm not. And of course, they don't really say those things. But the social worker will say, I've chased them around and they never give me a urine specimen, so I don't know whether they're using or not, but we told them if they don't give us a sample, then we're going to assume they're using, and that's usually what happens. If that's the case, if they're not going along with the program, I guess I'd call it. Or sometimes people do decide to get into treatment. And what Dr. Volkov says is it takes 90 days or so at least to start that full detoxification process. You might have a short-term program, 2 weeks, a month, but then for the brain to start to heal, it takes longer. So if we have the child removed, and then we've had an adjudication disposition hearing 3 or 4 weeks later, and then if the folks come back a couple, 2 or 3 months after that, if they're sincere and they see, oh, I'm in a jam, I better start doing this treatment, they'll be able to come back and say that they've started doing treatment. And for many people who have substance abuse problems, they also have mental health problems. So that requires another kind of treatment as well. Although at the health department, they have something called a dual diagnosis group for people who have both substance problems and mental health problems. But often people will go to 2 different places. So they're being required to do a whole lot. Much more than if they just went through criminal court and had a probation officer. Because they're also going to be asked to, or told to, or ordered to, get some parenting education. And to settle their life to a point where they would be able to take care of their child again. So many people have housing problems. They've lost their housing. They need to get some help and find a house, maybe a job. Sometimes when they're coming into court, the whole family has disintegrated. It's a very tense time. Not all the time, but for some folks it's really a very, very difficult time, and they're rebuilding their entire life to be able to focus on taking care of their child. That's what I would hope for them, is that they would say, oh, my goodness, I've lost my child. I need to deal with this. But sometimes in that drug-addled haze, people don't think like that. And you won't be dealing with the parents probably a whole lot. You may deal with the parent's attorney. Particularly later in the case, if people are at least doing some treatment, then we may get to a point where we're looking to the child transitioning back to a parent. And there are different plans that come about, and those plans, we start out with a plan of reunification. Federal law requires us to. Federal law, both spelled out as well as constitutional law, because we have a great respect for parents, if at all possible, being able to take care of their children. And here's where one of the big tensions comes about. Well, we say we're all about the kids, right? Well, the court is there and interfering in the child's life for the best interest of the child. And yet, at the other hand, you don't want to interfere in that child's life with a parent unless it's absolutely necessary. So, if you observe in court that I'm acting in a neutral way that you disagree with, I wouldn't be surprised, okay? Because if you are looking out for what you think is the best interest of the child, you may not be looking at that balancing interest. And I would ask you to think about that, because remember that young child who only knew mommy or daddy or both, and that was a child's life. There's no substitute for that person. That person might have a lot of problems. But most of our cases end up with reunification, quite frankly. So your role is very delicate. You don't want to encourage the child to burn bridges when in fact, not that you would, I'm not saying that you would, but I think it's a very tricky thing about how do we make sure that the child is well cared for with the idea that maybe this child's going back to mommy who did something wrong, who did not take good care of the child. but that might be a possibility. So for the entire first year or more, the goal of the court is to see if reunification can take place. There are very few exceptions to that. Almost all of our cases, reunification is the priority one goal, and it remains the priority goal up until the first permanency planning hearing. If you look at this, you'll see permanency planning hearing. They put it at day 330. Depends on how you count, but usually it happens around a year from the time of shelter care, give or take. Sometimes we'll have it sooner when the parent has totally given up. And if there's a pre-adoptive home available, why wait? But most of the time it happens around a year, and then the question is, there's a list. It's on the last page of the stapled together stuff, I think. This is out of our state law that deals with permanency planning hearings, and it lists in descending order of priority what the permanency plans should be. Number one, reunification. And then the next couple, all of the ones under two, which is two separate things. Adoption by a relative or placement with a relative for custody and guardianship. Deal with keeping the child within the family. So high priority given to keeping the child within the family. About 5 years ago or so, we had 200 or so children in foster care in this county. A couple of years after that, the number was cut in half by social services, doing some very interesting social work. They worked a little bit harder to try to find relatives who could take care of the children. Now, you might ask questions about them placing trust in a grandparent who didn't do a very good job in raising a parent, but that's a large number of children are now not placed in foster care officially. They're placed with relatives. And sometimes they go back to their parents, and sometimes they stay with their relatives indefinitely.
With reunification, how long does the court give a parent? Say that they give them the first year and the parents have not done the anger management and the parenting classes. How much further will the court go to be lenient?
Well, it depends, which is the answer to every legal question. And it's very frustrating to people who are on your side of the table. The federal law requires that we initiate an adoption unless there's a good reason, a really strong reason not to, if the child's been out of the parent's care for 15 months. 15 out of the last 22 months. And that's part of that 1997 law that I referred to. It's the Adoption and Safe Families Act. It wasn't called Adoption and Safe Families. You know, that first word is in there because that was one of the solutions to having children stay in foster care for years and years and years without ever finding a permanent home.
Right.
And this whole permanency planning process came out of that. Let's make a decision. Let's head in that direction. Let's get everybody heading in that direction. The court's going to make a decision. You know, the parents might disagree, and the social services has a different position, and the kid has another position. And then it's up to me, with the help of the judge, to sort out, okay, what's the direction going to be? And once the court says, okay, the direction here is going to be adoption, then social services has to file a petition. Parents are then involved sometimes in a rather large trial. Adoption, the termination of parental rights cases, which precede an adoption, happen all in front of the judge. I don't deal with that part of it. And those can be quite involved because it's death penalty for the family. It's totally cutting any legal ties between the child and parent. It's a big step. I believe that if parents are starting to go into treatment, they might not have gone into treatment the first 90 days. They might still be in full denial. But if we get close to that year, and they are at least showing some good faith effort, given the risk to the child of that final cutoff, it's worth another 3 months, from my point of view. And if I were sitting on the other side of the table, I'd say, why? You know, they're never going to shape up. I don't know that. And so I guess it's, some of our cases are stretched out a little bit because of that. Because I'm not sure that the federal law, when it was made up for this basically 1 year cutoff, was in line with treatment. Now, I've heard that, you know, you can get at least treatment started in 90 days and then be well on your way by the time you get to a year. And in some counties, they have special drug treatment courts for Senate children's parents. And most of those last about a year. And not all of them result in reunifications, but a large percentage do. We don't have the funds to do that kind of drug treatment court. We don't have the numbers really. And so instead what I've done is spend money indirectly by the attorneys having to be paid to come to court more frequently. In some counties, they come to court, they finish the disposition, they don't come back to court for 6 months, then they come to court 6 months after that. In a typical case here, we'll have come to court at least twice as many times as that. Sometimes every 2 months, sometimes every 3 months. With the idea of opportunity to tell people to get with the program and get into treatment, or to say, oh great, you're showing some signs of improvement, and here's what will happen now. We'll improve the conditions for your visitation. They'll be less supervised. They'll be more frequent. They'll be in your home. Other kinds of things like that that are incentives, in a sense, probably viewed by the parents as incentives, but actually they're also paving a path that should be safe for the child to start living at home again. And I'm fairly conservative about that, about making that a slow transition, because once the child's back home, you know, the Department of Social Services doesn't stay involved very long after that. So let's make sure that it's relatively safe.
What about physical abuse or sexual abuse? How does that play out?
Well, first of all, fortunately, we don't have that many cases. Most of our cases are neglect. Sexual abuse cases are very difficult. There is treatment available for adults, and of course there's therapy for children. The more typical profile is a stepfather or boyfriend.
Yeah.
And the mother then has a very difficult choice. Who does she love more? And more often the way it presents is not in that way. That would be the very judgmental way to think of that. Most people don't. But she might not believe it. And she was there and turned her back, or didn't see it, or
Didn't believe it.
didn't believe it. The most difficult situation I have seen is where the mother has the child and then takes up with a person who's a registered sex offender.
And she knows that, right? She knows he's a sex offender.
Well, we're not always dealing with the most sophisticated people who check out their boyfriend's records.
Right.
Sometimes she knows something, but he told me it never happened, and I love it. Emotions are strong. It's kind of hard for me to put myself in that role. So unless he leaves, it's pretty hard to solve that one. And the children sometimes go off with a relative somewhere else. But don't take that as a hard and fast rule. Every case is so different.
But if it's sexual abuse, why isn't he in jail? Or if it's
Well-
physical abuse where he threw somebody against the wall, why is he in jail, out of the picture?
Well, welcome to the world of the cross-section between criminal cases and what we would like to see happen. If a child is too young to testify in court and there's no other witness and there's no physical evidence, the person doesn't get prosecuted successfully unless he confesses. You can talk to the prosecutor sometime. I'm sure there's one prosecutor who's assigned to doing child abuse cases, and I'm sure she has a frustrating time sometimes. The social services investigates, they decide it really happened, they bring the case to the prosecutor, who's different than the social services lawyer. It's a woman who works for the state's attorney's office. And has to decide, can she prove by this really high standard, beyond reasonable doubt in criminal court, that something happened. It's really hard for young children. Older children, maybe. And of course, when there's physical evidence, a little much easier. You ask about sexual abuse, physical abuse. There was a case recently in Frederick, which is, I think, everyone's nightmare. I don't know what happened in court. I can only tell you what because I don't know. I never ask anybody involved in the court system, but what I've read in the newspaper is this. The child was battered when very young, 3 months, 4 months old.
Oh, it wasn't the 21-month-old one? No?
I
Just
don't
3 or
know
4
how
months?
long.
Okay.
2 months ago, I think this happened. Child was battered at very young age, taken away, went through the juvenile court process. Apparently, the parents must have done what they were supposed to do from their own point of view, at least. I think one of the things they may have done is not confess. So you had 2 parents in the home, injured child, and nobody wants to get criminally charged, so nobody confesses to what happened. All you know is injured child in the home, 2 people there. Assuming for the moment there was no criminal prosecution, I think they could have been criminally prosecuted for at least neglect, but that didn't happen. In the juvenile court, people do whatever it is they're ordered to do, whether it's anger management or drug abuse treatment or whatever. I don't know what they were ordered to do. And the child was returned and ended up dead a few days later. And that's why it's everybody's nightmare. Okay? But our system is set up not to produce that necessarily, but to produce the possibility of reunification if it's at all possible. And how do you shaken babies and broken arms of infants don't just happen. Although there is some new scientific evidence apparently about shaken babies, but broken arms on infants don't generally just happen. And so I believe in going slowly. And the scenario I just painted of 2 parents, nobody confesses, that's pretty common. They're going to get lawyers, and those lawyers are going to say, you don't want to spend 30 years in prison, do you? So they don't say anything. So hopefully we won't have to deal with those kinds of cases too often. And we haven't, fortunately. I would say broken arm kind of case once every 2 years. What happens here? What does happen?
I had a baby shaking syndrome last year with a broken arm. I had both of those. One child. Where both parents refused to testify or refused to
It's a
say who
common,
did it.
you know, I based that on experience of more than one case. I wasn't really talking about the
Right.
particular case you're
Right.
referring to. If you look at this last piece of paper, it's based on the federal law and the timelines that the federal law dictates. And our state law is based on federal law, so it should be in parallel. So I've thrown an awful lot of information in here. I haven't talked too much about what I expect of classes. I told you that I've been practicing law since 1985 after graduating in 1984. And I've never practiced in a system that had classes. I've been a kid's attorney, parent's attorney, never been a department's attorney. I've done the other two roles. And I've talked to people in other counties who say that CASAs can be very helpful. So you're going to have to prove that. We have not had CASAs in the past, thinking that, well, for the most part, the kids' attorneys here are very zealous. They look into the situations of their clients. They have fairly frequent contact with them, and they should be able to do that. And I guess I hope that you will be able to give, not necessarily contradictory to anybody's position, just another point of view, maybe about different details that somebody else is interested in about a child. I have not dealt with CASA reports, so I can't give you many tips except this. It won't necessarily be something that I will get to rely on. Okay. The court rules don't say it's automatically a piece of evidence. If you write something that's your personal opinion or your observations, more importantly perhaps, something that you saw, something that you could actually take the oath and swear to, because yeah, I saw that this was a bottle of Pepsi, and it was sitting on their table, and they were filling the baby bottle with it. I saw that. And you wrote that in your report, and the kid's attorney says, yeah, I want the master to see that. But the parent's attorney would read it and say, whoa, I don't want the master to see that. What would happen? Well, there might be an objection to your report. But then, there might be a solution. If you're there at court, and the DSS attorney or the kid's attorney want to, they could say, I want you to testify. Everybody who's testified in the master's court has survived so far. Only one person had a heart attack. Just go up there, take the oath, and tell the truth. And then you could talk about the people who were putting Pepsi in the baby's bottle, whatever it happened to be. And if you were asked your opinion, well, okay, you're a layperson, you can give opinions about certain things. It's not necessarily going to be the thing that controls the case. So, what am I trying to tell you? I appreciate your opinions, and you can express them, but more important than that, I think, are your observations. Okay? Now, observations can be what children tell you, and since all of the hearings you're going to participate in are after the disposition hearing, they will usually allow hearsay. Not that I give a tremendous amount of weight to hearsay, but they're allowed. You won't have that problem that I was talking about at the adjudication hearing. So you decide what you're going to put in. In terms of summaries of what's happened in the case in the past, might be good for you to refresh yourself, not really all that important to me. I've got past reports that I've written. I've got sometimes past reports that Social Services has written, and Social Services uses a template for their social workers and what goes in those reports. And they generally repeat things all the way back to the beginning of the case. When what I'm usually concerned about, if we're having a hearing every 2 or 3 months, is what's happened since the last hearing. Now, sometimes I need to remember, I apologize, but I don't always remember each kid perfectly. If we're dealing with, 80, 100 kids, and sometimes I need refreshers, so a little bit is fine. I think I saw some template for a concert report that had, put a summary of what the past history is and so on. I wouldn't put a lot of emphasis on that. I'd put more, I visited the child 6 times, and on April 24th, this is what I saw. And I contacted the social worker, and she said she hadn't been out to see the kid for 3 weeks. And so if you actually visited the child more often than the social worker, wow, good for you. If you were able to relay some information and get some action that wasn't happening already, that'd be good too. Good for me to know. Not that I'm not there to criticize social services or anybody really. I want to know what's going to happen to this child in the future. What can the court do to lay out a direction, whether it's a direction for social services or a direction for the parents that will lead to what seems to be a good result for the child. One final thing about which I'm sure Ms. King doesn't want to hear about. I'll pick on you for just a minute. The timelines say, cure things, get a permanent placement for this child as soon as possible. And so they say social services should file to terminate parental rights and arrange for an adoption as soon as possible, if progress hasn't been made. You go a year and a quarter, year and a half, and the parents just aren't shaping up, well, then we should do this other avenue. And people do adopt. And most of those adoptions work wonderfully, and the child has a permanent home. But then, it depends on the age of the child when they get adopted about what happens later. I've had children who were adopted who went back to their birth parents at age 18. I've seen adopted parents who have adopted children who were, say, early elementary school age, who've been terribly abused, who just couldn't take care of those children, and they bring them back into the system as teenagers. And when they're teenagers who've been previously adopted, they're just not adorable adoptables anymore, and they end up in foster care until they age out, as it's called. Now, Maryland is very fortunate for those older children that we have some things to offer, at least intelligent children, high intelligence children, and that's free college. If they stay in foster care or in the state's care past 18, they can go to state schools for free. That's a good deal. But if you're an 18-year-old who's not directly a group home, a couple of foster homes, you may just want to strike out on your own. You may be very impulsive, and you may think that you can conquer the world. And those are the most heartbreaking cases, and I believe you may end up dealing with some of those children who are 16, 17, 18. And their attorney, I trust, will try to persuade them. No, stay in foster care. We'll work it out. You've got a lot of options if you stay in the state's care. And I'm sure their social worker will try. But we've had a couple of kids who ended up homeless.
Or on drugs.
Well, they're 18, they think they know everything.
Well, of course.
We did.
Everybody who's 18 thinks that they're invulnerable,
that's right.
and that they
Nothing can happen bad.
they
can
want to
happen.
be in control of their lives. And they've been neglected. They've had traumas in their lives. They may not be thinking in the same way that some other 18-year-olds are. Being an extra person who can think creatively, not to hector or lecture the person, but to think creatively about how to help them satisfy what they say they want without burning bridges. Now, the law changed a few years ago so that a child who's in foster care